but I can actually prove my innocence. I actually can, and I'm not going to stop fighting to prove my innocence. I have more than enough, and Jonathan deserves to have the actual person who's guilty behind bars. I was helping Jonathan. I can show that I was trying to help him, and this I know is hurting the family, and I can see it in your faces, and I know.
In the Nevada 8th Judicial District Court, Judge Tiara Jones called the matter of the state versus Dion Michaels to order. Prosecutors Mr. Giovanni and Miss Griffith appeared for the state. Mr. Patrick stood for the defense. This was a sentencing hearing on one of the most serious charges this court handles. Both sides walked in with an agreed position already in place. In law, when prosecution and defense align before entering a courtroom, the range of outcomes narrows significantly. The judge still holds discretion, but the boundaries are set. Miss Michaels had something to say before those boundaries could be applied. What came out of her mouth did not just change the direction of this hearing, it changed the direction of the entire case and removed those boundaries entirely. And the moment it did, the person standing right next to her responded in a way that nobody in that room was prepared for. Judge Jones came in to close a case 2 years in the making. She did not.
On page 6, C 377239, State of Nevada versus Devin Michaels. May the record reflect that Ms. Michaels is present in custody. Mr. Patrick is here on her behalf. Mr. Giovanni and Ms. Griffith are here on behalf of the state. Mr. Date time set for sentencing. Are both parties prepared to go forward?
Yes, Your Honor. Yes, Your Honor.
All right, state, this is a stipulated sentence. Anything you want to add?
I do just a couple of things, Judge. First, we have 3 victim speakers. I asked if they permitted me speak last.
Okay.
We obviously went to a settlement conference. We stipulated this sentence. I think that the life tale reflects the gravity and the haunting nature of the facts. As you know, the defendant not only murdered her ex, but then desecrated his body by decapitating him and putting chemicals on his body, causing it to burn. The defendant admitted to the fatal blow. She never admitted to the decapitation portion, but the evidence was overwhelming that it was obviously her who did it. Another haunting fact, and something that should be concerning, which supports the life tale, is that the defendant had a corollary child abuse case that pre-existed this. We reviewed, Ms. Griffith and I reviewed the minutes in that case, and it appears that 2 days after she murdered and decapitated her ex, she appeared in court in front of another judge in this courthouse and made representations that she was staying out of trouble, and obviously had that on her conscience at the time, walked right back out of the courthouse, and then ultimately was developed as our suspect and arrested. We take this case very seriously, obviously the family does as well. We believe the sentence reflects the gravity of the crime, so we will submit it. We do have some updates on CTS, which was wrong in the PSI.
Correct. I calculated the credit at 455 days as of today.
Okay, that sounds correct.
Because I calculated it in regards to she was on probation when this event occurred. She then got that sentence imposed. She was released on that sentence, so she started accumulating the credit on that day. And I have it at 455 days as of today.
Yes, and we also have restitution requests. We've now received documentation. Right, we just received it this morning. We showed it to Mr. Patrick. It's supposed to be $5,000 to VOC.
I have that.
$1,923 to James Willett.
Hold on just one minute. $1,923?
Yes.
To whom?
James Willett.
Okay.
And $2,500 to Yoko Willett.
How do you spell the first name?
Y-O-K-O.
Okay. Mr. Patrick, have you seen this?
I have, Your Honor.
Okay, what's your position in regard to the restitution?
They had the documentation, we're okay with it.
Okay, state, I'm gonna need you to file that documentation. Because pursuant to the new case law, I can't order restitution without documentation.
Yes, ma'am.
All right. Ms. Michaels, what, if anything, would you like to say before I pronounce sentence against you?
There's something I want to say. Jonathan was very special for me, and I know no matter what I say at this moment, I know right now no one in the family is going to believe me. I know right now no one in the family feels that I am innocent at any point, and I understand that. but I can actually prove my innocence. I actually can. And I'm not gonna stop fighting to prove my innocence. I have more than enough, and Jonathan deserves to have the actual person who's guilty behind bars. I was helping Jonathan. I can show that I was trying to help him, and this I know is hurting the family, and I can see it in your faces, and I know your hearts are angry, and they should be, and I'm angry for you. And this is not fair to you. This has been dragging out for almost 2 years. It's not fair to you. And it's not fair to his children. Any of them. And it's not right. It really isn't. It's not. I've seen so much that it's just terrible. The way that they manipulated and altered and deleted things is wrong. They should not be able to do it, and they have. And for you to be able to look me in the eye knowing that the things are altered and...
You pled guilty, man.
Ms. Michaels, you are not to address the state. You are to address me.
addressing
You are.
the state. I
You're addressing Mr.
apologize.
Giordani. You are going to address me. What do
My
you want me to
apologies.
say? What do you want to say to me?
My apologies, I wasn't trying to address the state directly. It's just, I was told. I just told one thing after another, and I truly believed that we were going to do the right thing, and it just didn't happen. I am so sorry for all of this, but I am so sorry. But I didn't do this, and I didn't know this would end up like this. I really didn't. And I will forever apologize to the family. But I don't know how to fix any of this anymore. I don't. I keep listening to what everyone tells me is the best thing to do. Just do this and it'll work out this way, and follow this advice and we'll do this. And I keep listening to the people because they keep saying this is the best advice. It doesn't turn out the way they tell me it will. And it just gets worse and worse. And I don't know what to do anymore.
Judge, I'm not comfortable with this record. I'm willing to let her out of her plea if the court...
Here is what is happening underneath this moment. A guilty plea is a contract between the defendant and the court. It exists on the record. Walking away from it mid-sentencing does not simply pause the case. It hands the prosecution back everything they originally had. The original charge, the original exposure, all of it. Whether Judge Jones allows this withdrawal is her call. But if she does, the agreed framework both sides built over 2 years goes with it.
I don't know how to face this.
It's just, this wouldn't be appropriate.
I completely understand.
Let's go to trial.
Mr. Giordani. All right. Ms. Michael, Judge Mr. Giordani says that he's willing to let you out of your plea, and he's willing to try this case. And you understand that he's willing to try this case on an open murder. So a jury can convict you of a first-degree murder. Do you understand that? Or do you want to talk to Mr. Patrick about it?
I don't want to talk to Mr. Patrick. He didn't listen to anything I said.
Miss Michaels, I need you to understand what I'm saying to you and answer my question.
Yes.
Do you want to withdraw your plea and go to trial?
Yes, please.
All right. This plea is going to be withdrawn. Ms. Patrick, I need you to have some discussions with your client
Your
about...
Honor, I move to withdraw at this time. This case needs to go back to the appointed counsel.
Ms.
I will.
Michaels, hold on just one second. Ms. Michaels, you need to conduct yourself like this is a courtroom. If you cannot do that, then they're going to remove you because I still have business to conduct.
Yes,
Do you understand? Mr. Patrick?
Judge, respectfully, I move to withdraw and have this case sent back to Office of Appointed Counsel. I am not in a position to accept appointment on this case should it go to trial at this time.
All right. All right, I'm gonna have to reach out to the Office of Appointed Counsel and get her a lawyer that's going to be appointed with the understanding this case is 2 years old. This case is not going to sit stagnant and wait around for a trial. So I'm going to reach out to Ms. Bush myself and have a discussion with her in regards to the appointment of counsel, because this is not going to be, this case has been delayed extensively, and this case is not going to further be delayed so that there is no justice for everybody.
Yes, Your Honor.
And Your Honor, if I may, that's one of the other reasons, because with Barry Edwards, it would be late next year before I would even consider putting this on as a trial.
So I'll reach out to Ms. Bush,
Understood.
July 31st, 9 a.m.
And Your Honor, do you grant my motion to withdraw, please?
Yes, I'm going to grant your motion to withdraw.
Thank you.
Here's what happened after she walked away from that agreement. A Las Vegas jury heard the case and came back in just a few hours with a first-degree murder conviction and a deadly weapon enhancement on top of it. Judge Tiara Jones sentenced her to 28 years to life in prison before she even has a chance at parole. She came into that sentencing with a second-degree murder deal already negotiated. She left without it and faced a jury that did not need long to decide. That gap between second-degree murder and first-degree murder is not a technicality. It is the entire difference between what the agreed framework was offering her and what full exposure to the charge actually looks like when a jury gets involved. A sentencing hearing is not where the fight happens. By the time a defendant stands before a judge at sentencing, the options have already narrowed. That hearing exists to apply consequences, not reopen questions. Trying to reopen those questions at that stage does not reset the clock. It breaks the framework that was protecting you. And once that framework is gone, the prosecution gets to respond with the full charges. The full exposure comes back. The law does not let you have it both ways. If there is a case you want us to cover, tell us